there's temporary modifications and permanent modifications. What I've seen a lot of are these temporary modifications, very, very few permanent ones. The temporary ones really are a way of getting you to pay money to the bank. You're making less than your full payment, but you're making your payment, and you're getting no assurance that you're going to have any kind of ultimate resolution. So as long as that goes on, I've had clients who have paid for a year and then their servicer changes, and the new servicer comes in and says, sorry, but that modification's canceled because we have to do our own process. Here's the forms. Let's start over. Until you have a permanent modification, one that means that now this is your payment for the rest of your term of your loan, and you know what all the terms are, you have to recognize that you're not necessarily through this process yet. They can always deny your modification at the end of the day and continue to foreclose. And what I see over and over again is if they deny your modification, they will make demand that you repay all the extra money you should have paid, and then they'll go into the foreclosure. Now, HAMP is the government's program, which has its problems, but what you see a lot of are banks that say, okay, you don't qualify for HAMP, but you do qualify for my in-house modification. What that means is the banks have their own programs, which generally are less favorable to the borrower. I've seen some that make you waive defenses to foreclosure. I've seen some that at the end of the day don't really provide you very much relief for your modification. And the question I was asked before about does it make sense to sometimes work on our own modification, just to show good faith, if you get into a situation where you are entitled to a HAMP modification because the net present value test comes back that it will cost the banks more to foreclose than to modify, and the bank doesn't give you the modification under HAMP, you have a defense to foreclosure. It may not mean that you get your house for free, but it will certainly complicate things and give you more leverage as we move forward. So just some other points that I ask my clients always to consider when you want a modification is, do you need the house for the next 30 years? Is this going to resolve your short-term problems? Now, one of the things that a lot of people will have to understand is when you reject a modification, which is the early modifications they're giving, you're going to be in a lawsuit. But it's only a lawsuit. It is not nearly as bad as you might think, because it's not just you against the army. Matter of fact, there's more of an army against the banks. Since 2008, in Dade County alone, there's been 155,000 foreclosures and 25 circuit court judges. It got so bad that they had to bring back retired judges to try to clear the backlog, and I can tell you that there's not enough funding apparently now to keep those retired judges here, so it's going to be going back to division again, which will clog the courthouse, and the more difficult it is to prosecute a case through the courthouse, the more likely the bank's going to eventually have to do something. So what happened? Let's talk a little bit about how we got here today, that there's so many people in foreclosure. We talked a little bit about the securitization process, and what that allowed people to do, and Wall Street to do, was to take your loan, pull it together with 5,000 other people's loans, and sell them all together as one, what they called a security. It's like a stock. And they had a process that they were supposed to do to make these loans all go through a series of transactions that would outproduce a squeaky clean security that everyone could say would be AAA rated and a great investment. And what happened was they did great with this. So first it was our pensions and our police and fire unions that started investing. Then it was other institutional lenders. Then China got involved, and Saudi oil money, and everyone and their mother was hearing how we had these amazing AAA rated mortgage-backed securities, and there became a huge demand for it. And when there's a demand, you got to fill that demand. So what they started to do was to make it easier and easier for people to to qualify for loans. What they would do is reduce the underwriting standards I started seeing ninja loans, no income, no job applications, what they called them. They had a Disneyland loan. Was one guy who worked for Disney as a cashier and said he made $90,000 as a cashier for Disney, and they gave him the loan. They had this whole process that was intended to get more people to take out more loans with all these exotic, you can buy this house for no money down and it'll only cost you, pick a payment, it'll be $1,000 a month, and who cares if you're a waiter with your third property now, you can afford it. And what ended up happening was everyone started to believe their own hype, and they all thought this could go on forever. And you had rating agencies, which are the companies that were there, like Moody's and Fitch, who were supposed to be saying, we're looking at this deal from all the different aspects and telling you whether it's a good deal or not. And those guys were getting paid by these different banking houses that were creating these large pools of loans. And I guess they wanted more business because they didn't really look at all the facts on the ground and say, hey, these prices are not going to go up forever, and some of these people, more and more we're seeing, should not be getting these loans. And ultimately, once the housing prices tanked, that was the end of it. So let's talk a little bit about, if you are going to be in foreclosure, what are some of the basic rules? First off, you get to stay in your home during the fight. They cannot force you out. They cannot tell you have to take your tenant out if you have a tenant. They cannot take your rent unless you've expressly agreed to give them an assignment of your rents. They can't go into your bank account, although I will caution you to say that I have had some clients who bank at the same institution that holds their mortgage. And there are some banks that have agreements that allow them to go into your bank account if you are in default on one of your loans with that bank. So my recommendation is to consider whether you want to stay with the bank that you are currently going to get into a fight with, because if you're not there, they cannot touch any of your assets, not until they actually get an enforceable judgment against you. Something else to know is that normally, there is an exit strategy. The banks do not want your house. They would much prefer if you do a short sale. I've seen short sales done all the way up to the time of a foreclosure sale, and they will routinely allow you to continue the foreclosure sale in order to get a short sale done, because they would much prefer just to get their check than have to take the property and market it and so on and so forth. Now, the worst thing about foreclosure sale, I want to make sure everyone's on the same page. In my opinion, losing your home is terrible, and I do not intend to belittle that at all. However, the only thing worse than losing your home is getting hit by the deficiency judgment after that. So there are ways, once you go into litigation, to try to avoid that. First, there's court-ordered mediation. In Florida now, all homestead property, the banks are required to pay for and go to early mediation. In Miami, they have the Collins Center. In Broward, they have the AAA. The bank pays for the cost of it, and it's a chance to sit with someone at the bank, and talk to them and find out what they're willing to do. I will say that I've attended many of these, and that's really the only question that gets answered is what are they willing to do. It's not really the time to start talking about you're having problems with your securitization or this was a predatory loan or any of the other issues that are there. They're going to basically spit out whether you qualify for a modification or not, and if you don't, they'll usually tell you got to go try to sell the place. But it's there, and some people choose to take advantage of it. I've had some people that have a question here about what happens if you had a permanent modification, and now you can't make your payments. Well, you have to then try to do the same exact process we're in now, and you have to. I have to see the agreement to see whether you waived any rights. But not being able to make your payments means you're going to have to defend yourself against the possibility of a deficiency judgment. But going back to the mediation, courts will generally encourage parties to mediate. One of the things that my firm does routinely that we found a lot of success with is we move to compel mediation when the client is saying, I want to get this thing done and saved, and I'm not looking to have a fight. I'm willing to take whatever they're going to give me. If we have a fight on and we have something to talk about, we can also go and ask the court to order us to mediation. The way my orders read is first we have to exchange whatever documents we need to exchange, and then we have what we call a conciliation conference, which is basically a conference call with my client, myself, the bank, and the bank's attorney. There's no mediator present. And I find that the reason for that is I find the mediators really have no more leverage than I do in trying to push them. Some are a little bit more helpful than others, but really it's the bank making a business decision, and the mediators don't have the same leverage as they might with people that are not as familiar with mediation. But again, without having some what I would say meaningful defenses to the foreclosure and issues that you can raise and showing that you're ready to have a fight, I find that most of these early mediations result in very few meaningful loan modifications which will deal with an underwater mortgage and make it meaningful to stay in the property. If you come out of the mediation and there's sometimes I have a question here. Someone went to mediation and they never got the paperwork. Well, your lawyer should be following up with that. If there was an agreement, there should have been a document in the court file reflecting that. But if you haven't made your payments and you haven't followed up with the modification, sometimes it's going to be necessary to get back into court, ask the judge to send us back, because what we find is that the hardest part is getting someone on the line who will talk to us. These banks are overwhelmed with people. Having a court order and setting up a time and a conference call that people will be there, they seem to honor that. So let's talk briefly about the litigation process. Basically it's a lawsuit. The bank files it. There's a process server who will come out and try to serve you personally, meaning handing it to you or someone that lives in your house. If you dodge service or if you don't live there anymore and they can't find you, they have to do what's called a diligent search. And then they can get a guardian ad litem appointed, and they can try to service you by publication. That's basically putting an ad in the paper, and that allows them to move forward against the property, but they cannot get a deficiency judgment against you unless they serve you. If they get service within 20 days, they could move for a default. Some do, some don't. Some take much longer than 20 days. If they get a default, that means you waived your defenses to foreclosure. If I can make the strongest recommendation to make today is if you get served, find a lawyer within 20 days. Do not let the default get entered. It will waive significant efforts that you can use to try to make the bank prove their case and give you an opportunity to negotiate with them. If they have a default against you, they will try to push right past you. And by pushing past you, it means they will get to a summary judgment or they will go to trial and win. If they get summary judgment, which means that the court basically says there's an affidavit saying they didn't pay, their paperwork looks in order, there's no defenses that are being properly raised, there's no discovery outstanding, the bank will get summary judgment and a sale date will be set. If they win for trial, the court will set a sale date. The day of the sale is when the bank perfects its right to seek a deficiency judgment. How long does this process take, as a question I have. I have seen people that have been foreclosed out in as little as 5 months out the door with the sheriff there. I have many of my clients from 2008 who are still with me, who are still in their properties. So there is it's the average foreclosure in Miami is supposed to take 600 days. That is almost 2